Hello, my name is Jay Chauhan. I'm the mentor at the Angel Mentorship Group. And today's topic is family law of Ontario. And I want to just talk about the broader perspectives of the family law and to give you an idea that what you get in the educational system to understand the complicated net family property and all other issues of the family law and the history of the family law also can be helpful, but they are not directly practical in terms of the forms that you have to complete. And also, if you end up making an argument in the courtroom on dealing with that file, it is not possible to deal with it only the theory because the application of the theory in a practical situation is very different. So I just want to illustrate that with the example of the file that ICRA is now doing. But let me first give you a broader perspective of the profession at large as to what is not in the bar admission notes, not in the LLB training in the family law. I did family law also at Osgood Hall. And I remember distinctly in my class, there was a discussion about different theoretical issues of the changes in the family law history. Just going through quick history, that the history of Ontario family law comes from England, and the cultural norms of the society, including religious norms, became a part of the history of the law, of the English law, which was brought to Ontario, where you have to argue and practice the family law pursuant to those principles. So if you want to go right back to the history, it was Henry VIII, actually, who felt subjected to the Catholic religion of headed by the Pope in Rome. And he made a petition to him that he wanted to marry or remarry second time around. And the Pope rejected that idea. So he created his own religion in England, the Church of England, which technically is headed by the Crown of England. But that's the beginning. So up to the roughly early part of 16th century, the law that governed the relationship of marriage was religious law. But the civil law came into being. So when it did come into being, he started the arrangement of having the divorce recognized by the court system, which is civil authority. The civil authority took over in the adversarial system the arrangement for the divorce and separation. The initial years, it was supposed to be, including Ontario, when I practiced initially, was a statute called Deserted Wives Act. In other words, the presumption was that if wife deserted you, how much support would you give and be required to give? But all of that was roughly scrapped in favor of understanding that when a family falls apart, it is not necessary to try to find fault with each other, but it is important to try to figure out that there is a need for support. And I think the society has changed very much, enormously, so that women today are no longer dependent. Actually, if you look at the American statistics, actually, there's almost 40% of the American population is headed by a woman in the family. So she makes the income which supports the child. So there's a fundamental social changes taking place which affects the family law, which all of that are not shown in the context in terms of what you do in a particular file. But I think let's deal with the particular file or the file ICRA is dealing with right now, and how does it play out today? So from shifting the focus from the civil authority, when the religious authority declined and the civil authority took over, then the adversarial system in existence was used to try to accommodate the conflicts of the family. So what happened as a result is that a lawyer acting in Ontario, based on the English law, is taking over the carriage of the file to resolve the conflict based on the arrangement that you would actually not necessarily now any longer try to find fault with the other person, such as, for example, adultery, cruelty, separation for a number of years. These are still grounds for looking for a divorce. So essentially what has happened is that when there is a conflict and a breakdown of the family, you still have a lawyer who will take the initiative in the conflictual, adversarial, legal, competitive environment to try to resolve the issue. So there are a number of lawyers in Ontario who, like me, I'm one of them, who feel that that the adversarial system is not adequate and reasonable to try to resolve this issue. Let me tell you a couple of reasons why. And I have published an article, which I've also emailed to all of you, actually. If you didn't get it, you can let me know. It was published in Law Times about a few years ago, in which I made the following point. Point number one, that when the family breaks down, two people are earning income. Instead, each person is having to survive on their own. As you see, Ikra, in your file, then the question is the wife able to work? And then the one person will argue that she's able to work, she's got better qualifications, and therefore she should work. So it becomes, in the adversarial system, an arrangement to tell the judge that she is able to work and therefore she should not have that amount of support. So the adversarial system still comes into play to try to determine the way you find a resolution of the problem. It's not like sitting down in one room and saying, okay, we want to think in terms of how you divide the money, what is going to happen to the children. Nobody, in fact, the children are not a party to the action. That's, in my view, they suffer more than anybody else in the adults dispute, because the children, they may not be talking in the courtroom and they're not invited in the courtroom, but they suffer when they watch the conflict of the parents. It's very, very important to recognize that the common law system, where you want to resolve the issue, there is firstly no money, because the money is divided between the two people. Both are arguing about which amount of money should be paid to whom. And the Ontario created, to resolve the issue of the division of assets and the division of the support system, the essential principle was the net family property, in which the matrimonial home where the parties lived was to be divided equally. So I think when you have a situation where there is a matrimonial home, and there is a definition for it which says essentially that's the house that you lived in and that you intended to use it for the family, and therefore, regardless of the person who owns it, it should be shared in half the amount. I think there is some case law more recently that suggests that this half ownership may be questioned where the marriage has been very short. So in this particular case that you're dealing with, Ikra, there is a very short marriage. So I think that
2 years, if I remember correctly.
Yeah. So I think that we will have to deal with that issue. But I think that I want to make the first point that if you look at the statistics of what is happening in Ontario, I would say just a little less than 50% of families are separating in Ontario. So the business, if you like, is good, but there is not enough money to pay for the lawyer when the family needs the lawyer most. When the family needs the lawyer most in medicine, corona, the government steps in there and makes sure that you get your injection for free. I went to Markham. My parking was paid for by the government. My injections were paid for by the government. But if you take a situation of the family where the family is separating, there is no money to even pay the children their food, and then you have to decide whether you pay the lawyer or the children. It's an extremely tragic situation. So I want to, the statistics I cited in this article, that my research was that about 62% of the population of Ontario actually do not have representation. So let me give you an idea, which is not in the teaching materials, is that the way it normally happens is that people do not anticipate when they're getting married and they go to West Indies or Mexico for a kind of a special marriage and all the ceremonies. They do not think in terms of what is going to happen in terms of separation, divorce. And it is extremely, extremely difficult, not only because there is no money, but also because it is adversarial. So as you see from this particular example that we're going through, that you now have to point fingers at the other person. You will be able to make income. You will be, and the other person says, no, you had businesses. Where is the money? You're not showing the money. So what ends up happening, as it's happening in this case, Ikra, is pointing of fingers to each other in terms of how we should resolve the issue. And therefore, I think there are lawyers in my observation in Ontario who call themselves collaborative lawyers, who agree beforehand that if you have a family dispute, you are not going to go to court, and you will not try to make income out of the problem. So this has made it difficult also for me to deal with many family cases. So what is the reason for that is that there is a moral dilemma in your mind, actually, said, okay, should you take the money when the family is suffering and the children are suffering? So what is your duty? If you were a doctor, you wouldn't have this dilemma. If you're a lawyer, you do. So I think that family law is very commonly practiced by many young lawyers, actually. But the problem is that if you understand the structure of society and the context in which the system works, it is morally and ethically difficult for everyone, I would say. If you shut your mind to that one and simply follow the by-admission notes, you just complete the form, go to the courtroom, argue your point, you come home, and it doesn't bother you. But people like me do get bothered and worry about what happens in understanding the larger context of society. So I think that that brings me to the forms that are used, actually. Why there are some detailed forms, Ikra, actually. So what I'm watching in the forms is that if you were taking a regular file of litigation, you draft a statement of claim where the lawyer is the person who drafts the statement of claim. But because there are some specific details and that the public is going to end up at some point in time enthusiastically going to a lawyer who begins to charge hundreds of dollars an hour. I charge $500 an hour. So now you have a typical young lawyer actually charging $300 an hour, $250 an hour. It still mounts up to a large amount of money. Just to complete those forms, you're talking about a few $1,000s. So how do you deal with that particular completion of the forms? But the forms are designed in such a detailed fashion that the basic information gets across to the judge, even if there are no lawyers involved, which is the case in the majority of the cases today. So the forms are there to deal with the following issues, actually. The custody as to who will keep the child. Mostly until the age of about 7 to 10, most judges feel that the wife is a better person to look after the child. It's at the age 13 that you begin to look and say, the child is old enough to give their own evidence. And in the last few years, the system also recognized that the children's voice must be heard. So there are children's lawyers now also appointed at the expense of the government who would argue in favor of the children in their best interest. Because when people are involved heavily in the contested proceedings, they are not thinking about the children first. So the government is trying to step in through the child's lawyer, and he would then step in to take the position. There's usually a report created as to what would happen to the children and how to deal with the situation, and then bring it to the court as an independent report. So you can see that the method by which the common law system resolves the family law is, from my point of view, a little bit awkward, because it's adults' game in which the children are not involved. They are not fully heard. They cannot say things properly. They don't know if they should talk to the lawyer directly and give their evidence. The report of a psychologist may be given, and it may be taken by the lawyer to be brought to the court, and then some picture is given. But I think the fundamental assumption that the family will look after the children and the children do not know how to react to a conflict between parents, will end up saying things out of their fear that they might be disappointing some parent. They don't open enough. But that report psychologically is prepared, brought to the lawyer, to the court system these days. So these are some of the issues that we deal with when we deal with the family law. So I think to basically conclude that when you're dealing with the family law, I think it's very important to complete the form, and the tactic played between the lawyer becomes very critical. So in our case, Ikra, for example, why the opposing lawyer decided to issue the claim is, although we made big gestures to resolve the issue, she decided to bring it there because our client is not able to see that the sworn statement of the financial position of the parties is fundamental, and our client is not able to see that point of view. Why is the wife only married 2 years and there is a child should require the whole history of the husband's finances exposed to the rest of the world? Because once the case comes to the court, it becomes a public issue. So the wife doesn't want to disclose that public issue. So I wrote a note to the client that, and then of course, in this particular case, there was more difficulty because the parties were related to each other. The mother of the wife was related, and therefore, how much can you ask? How much will you bring it to the courtroom? That this is a relationship, and therefore more difficult to get information from, or the information may be biased, because we are now dealing constantly with the independent legal advice issue. So suppose you're getting married, would you then at that time see the issue as a conflictual issue? But common law sees it as a conflictual issue. So what happens is that even in a prenuptial agreement, you might have a lawyer writing on a whole big affidavit saying that I advise the client independently of the lawyer who acted for the opposing party. So I think in a summary, I think I sent the articles to all of you. And I think that notwithstanding the articles, that we have a system to deal with, we have our practical problems to solve, and that's how we'll be solving it, Ikra. So that's the conclusion of my family law observations. And so I think if you have any question, let me know, and I can answer it still on the recorded mode.
Not really a question, but I guess just to add to what you were saying, sir, I totally agree. I think the system is very adversarial, and the law does tend to be very paternalistic because it stems from religion and religious teachings. But you're right. I wish it like something that I would like to see is, lawyers worry more about what their clients are going through as opposed to getting paid, and taking matters to court if they really feel. And I mean, this is told in the bar admission notes, but practically speaking, like you said, most people are looking to get a paycheck. And I just feel like especially in family law, it's integral that we remember the ethics when practicing law, and we try to promote negotiation where it's morally right to do so, as opposed to coming off extremely zealous and making the matters worse for the family.
So this is why you can see, I think, Ikra, that in this file, actually, that I make big gestures to try to find the resolution, etc. But notwithstanding that, you can't change the system. But just to conclude this matter, I just want to let the rest of the group know that I gave a talk on the family law and the principles on which the family law of Ontario is based, namely the common law adversarial jurisdiction. And I want to conclude this recorded portion so that we can open up the dialogue with other people in the group.